Without further ado, I'm going to introduce our first guest presenter. Dr. Mick Keough is the Deputy Chair of the Australian Competition and Consumer Commission. Mick was appointed to the ACCC in February 2016 and then as the Deputy Chair in 2018 with responsibility for small business and agriculture. Mick's got a long, diverse history of employment with small businesses and agriculture sector, including working as a business consultant in the sector and advocacy and advisory roles to policymakers and governments. He is currently a member of the Commonwealth Government's Emission Reduction Assurance Council and a board member of the Food Agility Cooperative Research Centre. He's been the Executive Director of the Australian Farm Institute. He currently chairs the Water and Agriculture Board, the Supermarket Inquiry Board, that must be fun, Mick, and Competition Exemptions Committee. He's a member of the Enforcement, Compliance and Product Safety and Mergers Review Committees and Electricity Markets Inquiry and East Coast Gas Markets Boards. Mick was awarded the Order of Australia Medal in 2015. He holds a Bachelor's and Master's degree in Science at the University of New South Wales and a Doctor of Applied Science honoris causa from Charles Sturt University. He's very generously agreed to come in today and present on the technical and legal differences between mandatory and industry codes and the ACCC's position. Would you please welcome Dr. Mick Keough.
Thank you very much for that introduction, Troy, and thanks for the invitation here. As Troy's introduction probably identified, we've got the ACCC has quite a few roles and responsibilities, and it's often not well understood the nature of some of those roles and responsibilities. So it is useful to, I think, give a bit of background to the legislation and what we do, and that will lead me to a much more detailed discussion of industry codes, because they are quite an important component of what we do. So if I just start, don't worry, I'm not going to cue you with PowerPoints. I just felt a few points might be worth making. So we're an independent, the ACCC is an independent statutory authority established under its own legislation, the Competition and Consumer Act of 2010, and that succeeded what was referred to as the Trade Practices Act, but I don't know that that's of too much concern. But the important point is that the Competition and Consumer Act, Section 2 of that Act, basically says what the object of the Act is. And the object is to promote competition, fair trading and consumer protection for the benefit of all Australians. So that broadly gives us three specific roles. One is in relation to competition and trying to ensure that competition works well in the economy. So there's a range of responsibilities there. The most prominent ones are consideration of proposed mergers. So, for example, there's several proposed mergers of wine companies have been mooted and discontinued, and in most instances they would need to come under consideration by the ACCC as part of their finalisation process. So if any of those were to proceed, we would need to assess them. We assess them against their likely impact on competition, and should we not approve them, we can initiate court action to prevent those mergers occurring. So that's the competition part of our responsibilities. The consumer part of our responsibilities is two main areas. One is things like false advertising, misleading and deceptive conduct, and those sorts of areas where consumers are misled or treated badly. The second is product safety. So not only do suppliers of products have to be honest and fair in terms of what they say and what they do, but they also have to ensure that the products are safe. And we, for example, we administer recalls. So any of you that might perhaps have an LG solar battery at the moment may be aware that there's a recall, a mandatory recall there. That has come about because of work we did in terms of identifying the risk, making a recommendation to the Minister, and that triggered the recall. So that's our consumer protection area. The bit that's not, I think, as perhaps well understood in relation to our role is the fair trading bit. And there's a couple of reasons for that. One is because the fair trading bit is spread over both our main act, which deals with competition, Part 4 in particular deals with competition, but also the Consumer Act, because it relates to the ability of small businesses to operate fairly in the economy. And under the definition of consumer in our Act, a lot of small businesses fit within that definition. So where they're purchasing goods for less than $100,000 in value, for example, or motor vehicles, small businesses are treated as a consumer. Where they're purchasing products and services, they are covered by the same consumer guarantees that apply to a purchase by an individual. And that's not usually well understood because of the way our legislation deals with those particular issues. The other part of our fair trading role is under Section 51, and that's our industry code's responsibility. So under Section 51 of the Competition and Consumer Act, it creates a facility whereby industry codes or industry codes can be created and take different forms, and there's a range of powers that we have associated with that. So that, I guess that gives you a general perspective on our roles and responsibilities. As I said, the general provisions of our legislation, so the competition aspects and the consumer protection, which also apply to small business, apply generally right across the economy. So, for example, we've had some reforms in recent years to the law called the Unfair Contract Terms Law. And that's a law that basically says, in relation to standard form contracts that are presented to small businesses or consumers, so for example, your mobile phone contract or a contract, for example, for the supply of grapes, where one party in that is a small business, and that's defined as under 10 million turnover and less than 100 full-time equivalent employees, then that standard form contract is not allowed to contain unfair clauses. And I could go into the details of unfair, but I'm sure we'd spend all day talking about that. So suffice to say, where a contract clause is dramatically imbalanced in terms of rights and responsibilities to the two sides, then there's a risk that it'd be considered unfair and potentially trigger now, as of November last year, penalties if that is provided in that contract. That's relevant, of course, because when we did our 2018 wine grape market study, one of the outcomes of that was we identified quite a range of what we considered to be unfair contract terms in some of the standard form contracts offered by winemakers at that stage. At that time, it wasn't illegal to have those contract clauses, but they couldn't be relied on if a court deemed them to be unfair, and they would be voided. So in other words, a business that was putting those contract clauses in had the risk that a court would strike out that clause and they couldn't operate on them. As of November last year, they've become illegal and subject to penalties. So we did some work with some of the major winemakers and they modified a range of contract terms. I wouldn't say we were completely happy with where we got to. At that stage, we didn't have penalties. We now have that provision, so that is something to keep in mind. So that there's some general parts of our legislation that are relevant to the wine industry and the sorts of arrangements that people in this room might be entering into on a general case. But I guess it's a big but, and I know the next speaker will talk a little bit about this. One of the challenges we have is that we can't take action in every specific case that's brought to our attention. To spell that out a bit, we get about 500,000 contacts a year from consumers and stakeholders. Not all of them are complaints, but a lot of them are complaints. We have around 30 million as a legal budget that we can spend each year. We can also take some administrative action and issue, if you like, speeding tickets, what we call infringement notices, for limited amounts of penalty. But so basically, if you put those two together, 500,000 into 30 million doesn't go, because it costs you about, I would say, $1 million to run a case through the federal court. So we have to be quite specific in choosing which matters we can take forward. And so I think in recognition of that, the notion of industry codes has developed. So an industry code is a regulation, if you like, under our legislation that is specific to a particular industry or particular sector, and is a lot more specific in terms of its requirements and obligations on the relevant parties. So whilst everyone in this room is covered by the general provisions of our Act, the chances that a matter that might be brought to our attention would be strategic and important enough to attract us to take full legal action in relation to that are quite small because of just the simple limited resources that are available. So industry codes are in fact a way in part to overcome that problem and create a more specific piece of law that governs a particular sector. And so what I'm going to do briefly is just talk about the different forms that those industry codes can take. So I'll start with the first one. The first one is a voluntary code. So it's free for any industry to get together and develop a voluntary code. Now that voluntary code can take a range of different forms. A lot of professional associations have what is essentially a voluntary code of conduct. So real estate, legal practitioners, etc., etc. Most of them have some form of voluntary code. The voluntary code usually specifies minimum standards of behaviour, minimum ways of going about the particular business that they're associated with. And the aim is, I guess, in many respects, to create a minimum standard so that the industry can operate on a general knowledge of what's normal, what we should expect when we're doing business in this particular sector. There are a number of voluntary codes, and I know the wine grape industry has, or the wine industry has, a voluntary code in place. Quite a number of other sectors at different stages have had or still have voluntary codes in place. They certainly have their use, but I think it is quite important that in relation to those, there's really no specific role for a government or a regulator like the ACCC. It's entirely up the industry to self-regulate, if you like, to impose, in some cases as they do, disciplinary procedures. So, for example, there might be a range of measures that are introduced to try and keep members in line, I guess, but it's entirely up to the sector and the structures that are set up in that sector to give effect to those. And I guess a question always is asked, you know, just how effective can that be? In some respects, where everyone is agreeable and voluntarily works to try and achieve it, they can work quite well. A professional association, for example, that sets a minimum standard, and sometimes they're linked to registration, and sometimes that can be a very useful process to make sure the reputation of that particular profession isn't tarnished. But just reinforcing, it really doesn't create a role, or we don't have any responsibility in relation to industry codes, and they're not covered under that section 51 of our Act. The next type of code that I'm going to talk about is what's called a prescribed voluntary code. Now that might sound a bit like a contradiction in terms, but if I could explain it this way, a prescribed voluntary code is a code that's recognised under section 51 of our Act, but it's not compulsory for the industry participants to sign up to it. If they do sign up to it, however, they are bound by its requirements, and we can take limited regulatory action in response to a breach. In addition, they are covered by a particular section of our Act, which is section 51 ADD, and that enables us to conduct audits of compliance. So we can send notices out to participants in that sector and say, please furnish us, for example, these records that you are required to keep as a consequence of this code, and you signing up to it. There are some particular complications around a voluntary code in that the obligation to sign up to it is voluntary. So perhaps I can tell you by way of an example. So the best example at the moment is the current Food and Grocery Code. So the current Food and Grocery Code was developed by the supermarket retailers back in 2015. At that stage, the ACCC had conducted two legal cases, one in relation to Coles, where Coles had been, we allege, requiring suppliers to make an additional contribution to prop up the profitability of Coles at that point, and the claimed behaviour was that if you didn't make a contribution, your product would be delisted or at least deranged from the Coles shelves. So that case was settled. Coles agreed to settle it by making admissions that it had been behaving unconscionably, and it created a compensation fund for the affected producers that had been, or suppliers that had been delisted, and Jeff Kennett was the arbiter that sat on that and determined how much money went back to those suppliers that had been adversely affected by that. So following that, we had a case in the federal court against Woolworths for much the same behaviour, called the Mind the Gap case. In that case, the judge said, well, yes, Woolworths did lean on its suppliers to get extra money out of them, but it didn't actually threaten that they would be delisted, whether or not that was implied. So in that case, the judgment was that Woolworths hadn't behaved unconscionably. As a result of that, and the publicity around that, the supermarkets became aware that there was an imminent risk that they were going to face substantial regulation. So they got together and created a code. They agreed to allow the government to prescribe it under our Act. That meant they had to volunteer to sign up to it, but if they did sign up to it, then they were bound by that code and subject to our powers. Now, that code had no penalties associated with it, but it did have essentially a compulsory arbitration. Now, it's quite important to understand that normally under the Australian Constitution, a code can't have compulsory arbitration. In other words, a process of dispute resolution where whoever the presiding person is makes a final determination and says, you owe that guy $500,000, and that's binding. So normally under a code that can't happen, but under a voluntary code where the parties sign up to it, you can have that sort of code, because in a sense by signing up to the code, that sort of provision, because in a sense by signing up to the code they've agreed to be bound by the arbitration process. So the prescribed voluntary code has some disadvantages in terms of the parties don't have to sign up to it, but the advantage is there is a way around the compulsory arbitration provisions of the Constitution, because essentially the parties that sign up are volunteering to agree to be bound by arbitration. It's not mandatory unless you sign up. So we have surveillance powers or compliance powers in relation to that code. We can issue the supermarkets, for example, notices about whether they've kept the appropriate records, whether they've got written grocery supply agreements, a range of other things. But we don't have any penalty powers, so there's no penalties under that code. And I guess that's not surprising when you think of the history of it, because of course the supermarkets voluntarily put that code together, and you would hardly voluntarily put a code together and then include in it substantial penalties for yourself if you didn't follow it. So that's a prescribed voluntary code. The third form of code that I can talk about is a prescribed mandatory code. So again, that's a code that's recognised under our Act. It gives us significant powers in relation to both compliance, in other words, checking whether people are following the code, and enforcement, imposing penalties where there's a breach of the code. Probably the most relevant examples in relation to that, if any of you are involved in the horticultural production sector as well as the wine grape sector, you would be, in your relationship with agents at wholesale markets, for example, you would be covered by the horticulture code. The horticulture code is a mandatory code. It requires, for example, that horticultural agents must have a written horticultural produce agreement in place whenever they take produce from a producer and undertake to market it or sell it. So they have to have a written horticultural produce agreement in place. They have to publicly make available their terms of trade. In other words, what insurance, what commission do they charge, who pays freight, where does change of ownership occur, quite a range of those sort of provisions in relation to the transaction they have with growers. We routinely take compliance programs or undertake compliance programs with that code. So we will issue produce merchants with a 51 ADD notice and say, please furnish us copies of all the horticultural produce agreements you have in place with your growers for the last 12 months. They have to then provide them to us. We can check their compliance. We can also issue infringement notices. So there's a list of about 5 different produce merchants we've issued infringement notices to in the past 12 months, either because growers reported them to us for a breach of, or what they claim was a breach of the code, or because we conducted a compliance audit and they weren't complying with the code. So that, under that code, however, whilst it has a dispute resolution process, it can only amount to what's referred to as a mediation process. So in other words, and I know Bruce Wilson will talk about this in detail shortly, it can be a dispute resolution process that's initiated in front of a presiding person. That presiding person can hear the arguments either way and perhaps give some guidance or advice, but cannot make a binding decision about the outcome of that dispute. So it's mediation as distinct from arbitration, where the presiding person can say, right, you owe him or you owe her X dollars and you have to pay it. So that's quite, that mediation word versus that arbitration word is quite important to understand, and just reinforcing that under a mandatory code where involvement in that sector mandates that you must follow that code, you can't have dispute resolution that ends in arbitration. Well, you can have it in arbitration if you voluntarily agree to it, but the code itself can't require mandatory arbitration as part of the code. So what does the Horticulture Code cover? In addition to that, it talks about timing, it talks about transparency in terms of payment, it talks about where the horticulture agent is a merchant, that they have to provide records back to the grower of what they on-sold their produce for, and a range of those sorts of things. The other mandatory code that we administer is the Dairy Code. The Dairy Code came in 2019 as a result of a significant event in the dairy sector. Some of you may have been familiar with, where a couple of the major dairy processors got into significant trouble when China closed down an avenue of export that they had available. The contracts that they had in place at that stage actually had retrospective price adjustments. So in other words, even though they'd already paid farmers for the milk that they'd supplied, under the terms of their contract, that could be regarded as an overpayment, and they could claw that back. And so Murray Goulburn and subsequently Fonterra both enacted, or certainly Murray Goulburn enacted those clauses and actually sent notices to dairy farmers in April and May of that year that for the year ending in June that year, those farmers actually owed money back to the organisation under the terms of their contract. So that led to, so what that highlighted was the imbalance in negotiating power in those contracts. We recommended a dairy code that was subsequently adopted by the government, and that has made, for example, retrospective and clawback provisions in those milk supply agreements illegal. It's also put a time frame, and this is probably relevant to the wine grape industry, it's put a time frame around when, for example, milk processors have to have their price offers on the table. So you may have seen in the news the last couple of days, Dairy Day is the 1st of June. Under that code, all the processors have to put their price offers out on the 1st of June for a milk supply year that starts on the 1st of July. So that's to ensure dairy farmers have 30 days to look at the competitive offers that are available and decide who they're going to sign up with. Prior to that, some of the processors wouldn't put their price offers out until after the 1st of July, and they had contract clauses that said as soon as you supply after 1 July, you are deemed to sign up a contract. So there was those sort of arrangements in place at that stage. So you can see that those two codes, the Horticulture Code and the Dairy Code, they're mandatory codes. Just reinforcing, they do have dispute resolution processes in them, but they don't have mandatory, if you like, arbitration associated with them. But they do have a whole range of other measures setting out the standards that should apply. We can take surveillance action and we can take enforcement action for breaches of that code. And we've recently, for example, had a substantial increase in the threshold for penalties. So we can now not only issue infringement notices, we can now issue court proceedings for major breaches and impose penalties. And for example, we recently took one of the major dairy processors, Lactalis, to court for breach of the code, amongst other things, and the court handed down $1 million fine. So that's under the Dairy Code. So there's some real teeth in a mandatory code in terms of enforcement, despite the other limitations that I spoke about. So you're now almost qualified as legal practitioners, I think. Perhaps bush lawyers might be closer to the mark, which is what I am. So just summing up the advantages and disadvantages of different sorts of codes. Certainly you can have provisions in them which require increased transparency. So for example, if you think about the Dairy Code, it requires the processors to put their prices out on the 1st of June for all to see. So it becomes a very transparent process, if you like, if you're a dairy producer, in choosing between what particular offer you might take up for the next year. It could, for example, also increase transparency in terms of information available post-transaction. So in other words, market information, things like the volumes of supply, things like the prices that have been paid, those sorts of things could also, if you like, be incorporated into a code. It establishes minimum trading conditions. For example, the requirement to have a documented agreement in place, the elements of that agreement that have to be there, and those sorts of things. And those provisions can correct the imbalance in bargaining power, for example, where there might be multiple producers and only one or two outlets for that product, and those one or two outlets have essentially all the information and very much greater bargaining power than the multiple individual producers that are supplying them. The disadvantages, as you could imagine, where an industry is characterised by a whole range of different ways of doing things. For example, some forward contracts, some spot market, some long-term agreements of some sort. The flexibility can be a bit limited, if you like, because you're trying to create a standard process, if you like, of business transaction for the industry. So there can be flexibility. It can be, in certain circumstances, a barrier to the introduction of new ways of doing business. If I could give you an example of that, there was an attempt to move to a more risk management based model in the dairy industry, whereby both processors and growers could perhaps negotiate options 12 to 24 months in advance before the year started. So in other words, a long-term risk management. The argument at the time was that the provisions of the Dairy Code, by specifying, as it did, a minimum price for the season, took some of that flexibility out and made it less viable to introduce that sort of longer term forward commitment, for example, that is more common in the cotton industry. It's arguable whether that's the case or not, but they're the sort of things that may mean that, for example, risk management options that might be viable absent the code might be constrained, if you like, by the code. And in certain circumstances, it can exacerbate power imbalances. For example, we would argue that the horticulture code, as it stands at the moment, with what's referred to as a merchant agreement, entrenched the ability of produce wholesalers to receive produce on consignment, sell it when they felt like it, and absolutely minimise the amount of information that went back to growers. And typically we see growers receiving a note that says proceeds of sale X, less 15% Y, your proceeds, with no details whatsoever on what that product sold for. Now that's a consequence of clauses being inserted into that horticulture code that allow what's referred to as a merchant agreement to be in place. So there can be situations where a code's not well developed that in fact exacerbate rather than improve situations in an industry. So that's given you a bit of a cook's tour, if you like, of codes and what they do and how they work and how they sit in our legislation. As you can see, there's some complexities and some considerable advantages in relation to codes. And I think I'd probably emphasise the other thing is, the big advantage of codes is they're not substantive legislation. So once government and industry agree on a code, yes, it has to be laid on the floor of Parliament, but it doesn't have to be considered by the Parliament. Unless the Parliament disallows it, the code is therefore enacted and away you go. So it doesn't have to go through the process of being debated as legislation and going to the Senate and going to the House and back and forth and all the politics associated with that. So much more streamlined in terms of the way in which a code becomes part of law, and obviously that also means that in terms of modification of a code, the options are much simpler than having to get substantive legislation amended through the Parliament. So I'll stop there I could keep going, but I better not.
Ladies and gentlemen, would you please thank Dr. Mick Keough?